Chapter 20. Criteria of Domicil, or the evidence by which domicile is shown. SS 362. Recapitulation of general principles of evidence already referred to. It has been frequently remarked that domicile is a mixed question of law and of fact. Having disposed of that branch of the subject which may be more properly termed the law of domicile, having discussed its definition, its nature and classification, its attribution by law and its acquisition by choice, its relation to particular classes of persons and to particular places, etc., we come now to consider the evidence by which it is shown, and it may be well here to recapitulate a few principles of evidence already referred to, namely, domicile of origin is prima facie at the place of birth, subject to correction upon proof that the parent was domiciled elsewhere at the time of the birth of the child. The domicile of origin of a foundling is prima facie where he is found, subject to correction upon discovery that he was born elsewhere, or upon discovery of his parents domiciled elsewhere. Domicile once shown to exist is presumed to continue, and the burden of proof rests upon him who asserts a change. It requires fewer circumstances to show a change of municipal than of national or quasi-national domicile. The same is true as between quasi-national and national domicile, though in a less degree, slighter proofs being required to show a change of the former than of the latter. It requires stronger proofs to show the acquisition of a domicile of choice, and derogation of a domicile of origin than the substitution of one domicile of choice for another, and slighter proofs than either to show a reverter of domicile of origin. Domicile of origin clings closely and reverts easily. SS 363. The discussion relates directly to the domicile of independent persons. With respect to the domicile of dependent persons, there need be no discussion here. To ascertain the domicile of such a person, all that is necessary, the dependence being shown, is to go a step farther back in the inquiry, and to ascertain the domicile of the independent person upon which depends the domicile of the person in question. The discussion here will relate to the evidence by which the acquisition and loss of domicile of choice by independent persons are usually shown. SS 364. The necessary factum simple and easy to prove. We have seen that into a change of the domicile of an independent person two elements enter, factum et animus. The factum, which is the transfer of bodily presence from one place to another, is usually capable of easy proof. It is purely a physical fact, generally open and notorious, and rarely in dispute, and there is, therefore, no need for resort to inference, presumption, or a nice balancing of conflicting proofs. Residence and change of place are obvious and cannot be mistaken. SS 365. The necessary animus complex and often difficult to prove, but with regard to the animus or intention with which the change of bodily presence is made, it is otherwise. That is a mental fact and, therefore, more difficult to discover, and liable to misconception and dispute. It is provable in two ways, namely, by the testimony of the person himself, and inferentially or inductively by the proof of other facts, which are physical in their character, and, therefore, capable of proof by means other than his testimony, and which tend more or less strongly to indicate the mind of such person. Acta exteriora indicant interiora secreta. But when we come to inquire what facts are to be taken as indicative of intention, we are met by great difficulty, so great that, to use the language of Shaw, C.J., the questions of residence, inhabitancy, or domicile are attended with more difficulty than almost any other which are presented for adjudication. SS 366. Each case must be determined upon its own circumstances. The circumstances which go to make up the lives of different individuals differ so widely that no two can be judged precisely alike. What would be highly important and of great probative force in the case of one, may be trifling and meaningless in the case of another, said Rush, President, in Gear v. O. Daniel. Employments of the most opposite character and description may have the same effect to produce a domicile. A man may be alike domiciled, whether he supports himself by plowing the fields of his farm or the waters of the ocean. It is not exclusively by any particular act that a domicile, generally speaking, is acquired, but by a train of conduct manifesting that the country in which he died was the place of his choice, and, to all appearance, of his intended residence. The sailor who spends whole years in combating the winds and waves, and the contented husbandman whose devious steps seldom pass the limits of his farm, may, in their different walks of life, exhibit equal evidence of being domiciled in a country. Hence, it is impossible to lay down any positive rule upon the subject, but each case must be judged by its own facts and circumstances. SS 367, ID, Lord Penzance, in Sharp v. Crispin, remarks, did he voluntarily adopt England as his home and domicile with the intention of renouncing and abandoning the Portuguese domicile which his origin had conferred upon him? I was much struck with the argument that such a resolve ought to be indicated by some acts or words of a marked character, from which definite intentions of a permanent nature might be safely collected. But while admitting this as a general proposition, it is, I think, sufficiently obvious that the mode in which a man may be expected to evidence his intentions on such a subject must vary indefinitely with the age, character, circumstances, and general conduct of the individual. In canvassing the words and actions of a youth just emerging from minority, and still wholly dependent on his father, one would not expect the intention, if it existed, of making England his home to be evidenced by such acts as would be likely to attend the resolve of a mature man of business. Nor would it be reasonable to look for conduct such as might be evinced by a healthy, energetic youth in the full use of his faculties, in one who was neither healthy nor energetic, and whose mental faculties were weak, if not yet unsound. I am far from saying that this last condition dispenses with the proof of the intention in question, or that the existence of the intention, in all its fullness and completeness, must not be arrived at by the court before a change of domicile can be declared. But I am speaking of the media of proof, and I hold it to be unreasonable to require any further proof to this end than the individual, such as he really was, might fairly be expected to have furnished in the circumstances in which he was placed, if he had, in fact, really and truly entertained the intention of which we are in quest. SS 368, ID. To the same effect was the language of Dr. Lushington, speaking for the Privy Council in Hodgson v. De Beauchesne, with respect to the evidence necessary to establish the intention, it is impossible to lay down any positive rule. Courts of justice must necessarily draw their conclusions from all the circumstances of each case, and each case must vary in its circumstances. And, moreover, in one a fact may be of the greatest importance, but in another the same fact may be so qualified as to be of little weight. SS 369. All the facts of a man's life evidence of his domicile. It frequently happens that there appear a few simple and decisive facts which relieve a case of any difficulty. But, on the other hand, it also frequently happens that the prominent facts in a man's life are so nearly in equilibrio that resort must be had to the closest scrutiny of his whole life and conduct before any definite result can be reached. There is, therefore, no fact which is of itself conclusive evidence of intention, and, on the other hand, there is scarcely any fact too trivial to be of service on occasion. We must look to all the facts down to the last moment of his life. Acts and declarations, conduct, mode of life, habits, disposition, character, age, circumstances, pursuits, domestic relations, family, fortune, in health, and, in short, the whole history of the man from his youth up, furnish the criteria by which intention is to be determined, and the determination is to be from the preponderance of evidence. SS 370, ID, Kindersley v. C., who has considered this subject in a number of cases, says with great force, in Drevon v. Drevon, but whatever is the definition, if you could give one, of domicile, what are the acts which are sufficient to constitute a change of domicile? It leaves you much in the same difficulty even as you are in as to its definition. I think the court has been under the necessity of doing this in all cases, taking all the acts of every kind, more or less important, throughout the man's life, upon which you can have evidence, taking not only his acts, but his declarations valent quantum, and then judging whether the testator did or did not mean to give up his domicile of origin and adopt a new one. I may say with regard to the evidence of acts, there is no one circumstance that has ever been brought to the attention of the court in any of the cases, as to which I think it may not be truly said that in some of the cases that occur, that act or that circumstance which has been treated as of great importance. In other cases, that same act or circumstance has been treated as of very little importance. For example, the first fact generally brought forward, and, of course, which is brought forward and relied upon in this case, is length of residence. Length of residence has in many cases, both by English and foreign jurists, been considered a very important ingredient in the question, and in other cases it has been considered of as little importance, that is, as compared with and brought into connection and contact with other circumstances of which evidence is given in the case. I think with regard to that point, the true conclusion is this: not that any one act or any one circumstance is necessarily per se of vast importance and other circumstances of little importance, but it is a question what is the relative importance of the different acts, whether some acts tending one way are of greater weight than those tending the other as to the animus menendi, or the animus revertendi, or the animus as to changing domicile. I think this also may be said: there is no act, no circumstance in a man's life, however trivial it may be in itself, which ought to be left out of consideration in trying the question whether there was an intention to change the domicile. A trivial act might possibly be of more weight with regard to determining this question than an act which was of more importance to a man in his lifetime. SS 371. Probabiles conjecturi. John Vogt remarks, with reference to the determination of domicile, quatis autem non certo constat, ubi quis domicilium constitutum habeat, et an animus sittendi non decidendi, ad conjecturis probabiles recurrendum. Ex variis circumstantiae petitas, etsi non omnes ec firmi, aut singuli soli considerati non ec urgent sint, sed multum in iis velat judicis prudentes et circumspecti arbitrium. In this connection, Kindersley v. C. may again be quoted: there must be the act, and there must be the intention, and in order to decide the question of intention there are undoubtedly a number of circumstances which are considered by the law of this country, and probably by the law of almost all other countries, as affording certain indicia or criteria, from which you may infer the intention one way or the other. But it is obvious that some of the circumstances may have a tendency one way and some the other way, and very often it is extremely difficult to come to a determination among the conflicting tendencies of the different circumstances on the different indicia of intention. In all questions of this sort you are obliged to resort to what are called by some of the jurists probabiles conjecture as to what his intention was to be inferred from circumstances. Perhaps the more correct expression would be probable prescriptions, rather than probable conjectures, though those prescriptions are in great degree founded upon conjectural reasoning upon the circumstances. $372. Facts to be construed untechnically and according to their natural import. Lord Cranworth, speaking on this subject in Maxwell v. McClure, said the question of domicile turns entirely upon the facts of the case, and upon the construction which, as men of the world, we should put upon the acts of parties as disclosed in the evidence. Demoulin, after pointing out a few of the usual indicia of domicile, concludes, it belongs, then, to the magistrate to appreciate the importance, the priority, the isolation or the concourse, and the force, more or less probative, of all these elements constitutive of the domicile of each one, regard being had to his particular position and personal habits. SS 373. Certain facts usually entitled to more weight than others. But whatever difficulty there may be in laying down any positive rule which will fit all cases, or which will give to certain facts, under all circumstances, greater probative force than to others, courts and jurists have laid stress on certain facts, either when standing by themselves or when corroborated by, or opposed to, certain other facts, leaving their force to be strengthened, diminished, or entirely destroyed in other cases by the appearance of new circumstances. Indeed, the great bulk of what has been said in the decided cases has been by way of appreciation of given facts as determinative of intention, and while they are to be used with caution and tested thoroughly by the circumstances of each particular case, certain approximate values have been set upon certain things as indicia of intention, or, as they are sometimes called, criteria of domicile. SS 374. The definitions of domicile in the Roman law, mainly formulae of evidence. The so-called definitions of domicile which are to be found in the Roman law are for the most part formulae for the ascertainment of the necessary element of intention, and while they are largely figurative, They point out certain criteria of fact, which doubtless must have had a much more definite meaning to the Roman mind than to ours. Thus, the definition of the code puts the location of the lares and rerum ac fortunarum suarum summa as tests, and eadem loco singulos haber domicilium, non ambigitur, ubiquis lam. Rerunc ac fortunarum suarum summum constituit, under versus non sit decessuris. Si nihil avasit, under cum proftus est, peregrinari viter, quod si redit, peregrinari jam destitit. Alphenus Varus puts the location of the seats at tabulae and the suarum rerum constitutio as the test, sed dei reconstitutum est. Eam domum unicuit nostrum deber existimeri, ubiquis seats et tabulas haberit, suarunc rerum constitutionem fecesset. But Ulpian, most of all, lays down a formula of criteria as follows: si quis negotia sua non in colonia, sed in municipio semper agit, in illo vendit, emit, contrahit, eo in fora. Balneo spectaculis uditer, ibi festos dies celebrat, omnibus denic municipii commodis, nullis coloniarum, fruiter, ibi magis habere domicilium, quem ubi colendi causa diverseter.